Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. This week, Senator Chris Murphy introduced legislation in the Senate, quote, to promote due process and improve fairness in immigration proceedings, end quote. Boil down, this introduced bill gets rid of matter of Lozada's bar complaint requirement and tethers ineffective assistance of counsel claims in immigration court and before USCIS to the well-known Supreme Court's Strickland v. Washington standard applicable in all or nearly all other areas of law besides immigration. For a variety of reasons that can only be attributed to fortune and the weird twists and turns of life, I was involved with Rekha Sharma Crawford, Ayla National, and others in advising the senator and his staff on this bill. It was an eye-opening, exciting, and at times stressful experience, and I was honored to be part of it. I've linked both the senators and Ayla National's statements in the show notes, as well as the actual bill that again is now introduced in the Senate. If you, like me, believe that the BIA's 40-year-old requirement that immigration attorneys place their colleagues' professional and, in extreme cases, actual lives at risk by requiring the filing of a bar complaint to obtain relief for their clients where ineffective assistance of counsel occurs, I urge you to share the statements as you see fit and advocate for this bill. Special thanks to Ayla for advocating for something that truly helps both their member attorneys and non-citizens alike. And thank you to Rekha in particular for spearheading and spearfishing this issue for so long. No ineffective assistance of counsel on the pod this week, so no foreboding ineffective assistance music. Just 5 interesting cases. And of course, if you didn't catch the interview with Eric Lee about the Supreme Court's Munoz decision, go listen to it. Like right now. Listen to this episode and that one at the same time. Here are the cases. First up is Azumah v. USCIS, published by the 4th Circuit on July 9th, 2024. This is a decision of momentous importance on naturalization. Mr. Azumah is from Ghana and was admitted to the United States as a lawful permanent resident in 2010. 2 years later, he was arrested for stealing clothes from the Sears department store. R.I.P. Sears. Although Google tells me that there are actually 13 stores remaining in the United States. Who knew? Google knew. Mr. Azumah pled guilty to misdemeanor embezzlement under Virginia Code Section 18.2-111, and everyone seems to agree that that's a crime involving moral turpitude, committed within 2 years of obtaining LPR status, so he's removable for it if it's a CIMT, which again, everybody seems to agree that it is. It also would then make him inadmissible if he left the United States and came back, notwithstanding his holding LPR status, which is exactly what happened when he left to go visit his family and tried to return in January 2014. CBP paroled him in for removal proceedings. But those proceedings never happened. Quite oddly, Mr. Azumah admitted the charge of inadmissibility, but then moved to terminate proceedings so he could apply for naturalization. DHS jointly moved to dismiss the case after that. Good work, counsel. Important too, because USCIS won't naturalize someone if they're in active removal proceedings, and USCIS sometimes begins removal proceedings for this very reason when somebody applies to naturalize that USCIS believes is actually removable. Anyway, Mr. Azumah applied to naturalize, but USCIS denied it and then affirmed that denial on administrative appeal, the N336. In essence, USCIS believed, correctly, that because of his embezzlement conviction, DHS had considered Mr. Azumah an applicant for admission when he tried to re-enter in January 2014. INA Section 118.13c(v) does permit this, that is, charging an LPR with a CIMT conviction who leaves the United States and tries to come back in as an applicant for admission. But USCIS then took that one step further. It held that because of this, Mr. Azumah was not, quote, lawfully admitted, end quote, upon his last entry into the United States, and so he couldn't naturalize under USCIS's unique reading of the statutory naturalization framework that I'll get to in a bit. A district court judge agreed with USCIS when Mr. Azumah sued, but the Fourth Circuit did not, because, well, USCIS has gone a bit rogue with its regulations as compared to the actual naturalization statute. Ultra vires, in lawyer terms, says I, although technically not this decision. Naturalization is governed by INA Sections 316 and 318, although make sure to cite to the U.S. Code sections when you're in federal court. Both require that a naturalization applicant have been, quote, lawfully admitted for permanent residence, end quote, in order to naturalize. By regulation and adjudications, USCIS has read this term to mean much more than simply obtaining a green card, which is lawful permanent resident status. USCIS believes that this phrase actually allows it, USCIS, to do a full-on reanalysis of whether the LPR was actually due LPR status when the LPR got LPR status, and that if something was wrong, really, if anything was wrong, USCIS can deny naturalization. LPRs get in trouble all the time because of this when they apply to naturalize, and their cases are discussed in removal proceedings on the podcast. Don't apply to naturalize without a lawyer. Here, USCIS is being a bit more nuanced. In this case, USCIS believed that Mr. Azumah was never actually lawfully admitted in 2014. He was paroled after being deemed an applicant for admission, and his admission, or application thereto, was never actually resolved in those removal proceedings. It's not crazy. It actually sounds like a law school exam. But explained the Fourth Circuit by quoting in part INA Section 101A20, quote, perhaps counterintuitively, the phrase lawfully admitted for permanent residence, as used in the INA, has nothing to do with admission at all. Instead, it is a term of art, statutorily defined, that refers not to an applicant's admittance, but instead to his status, the status of having been lawfully accorded the privilege of residing permanently in the United States as an immigrant in accordance with the immigration laws, such status not having changed, end quote. Or to paraphrase, and I guess at least in this context, for naturalization purposes, the phrase lawfully admitted for permanent residence means holding LPR status. Mr. Azumah had that. Notwithstanding being treated as an applicant for admission in 2014 because he got that CIMT and left the U.S., Mr. Azumah has always been an LPR because no immigration judge ever took his status away. No final order of removal exists, as is required for someone to lose their LPR status under the regulations when they're in the United States. That Mr. Azumah appears totally removable because he got that CIMT within 5 years of admission is irrelevant. He has no final order of removal, in part because ICE agreed to jointly terminate his removal proceedings as a proper exercise of its discretion. The statute, explains the Fourth Circuit, requires only that the non-citizen currently hold LPR status to be eligible to naturalize, in addition to other things not relevant to this dispute. And this is where it gets really interesting for other cases. Unable to make a statutory argument, USCIS relied on its own regulations, 8 C.F.R. Section 316.2b to be specific. That regulation, titled burden of proof, states that the naturalization applicant has the burden of establishing that, quote, the applicant was lawfully admitted as a permanent resident in the United States in accordance with the immigration laws in effect at the time of the applicant's initial entry or any subsequent entry, end quote. USCIS made this last part of its regulation up and makes it sound official by putting it in a regulation. But that last phrase is nowhere in the statute, explained the Fourth Circuit. It is an additional requirement that Congress did not see fit to put into law. Here again, the more nuanced argument was that Mr. Azumah was never lawfully admitted during his last entry in 2014. He was just an applicant for admission, his application was never resolved, and he was simply paroled in. Didn't matter to the Fourth Circuit, nor did USCIS's regulation matter. The phrase, quote, lawfully admitted as a permanent resident is simply, clearly intended to reference the substantive requirement of LPR status found in Congress's naturalization statutes, end quote. Nothing more. USCIS added a requirement in its regulation, and that is a huge quote from the Fourth Circuit. Now, the Fourth Circuit doesn't quite find 8 C.F.R. section 316.2b ultra-virus of the statute. Instead, it reads the reg as requiring the same thing as it reads the statute requiring, textual differences notwithstanding. Indeed, in our post-Chevron and our deference world, reading the regulation otherwise, quote, would raise difficult questions about the agency's authority to add to Congress's statutory naturalization requirements, end quote. The Fourth Circuit goes through the statutory and the regulatory history a bit to explain why further. And while the facts of this case are a bit unique and narrow, some of the language used by the Fourth Circuit is not, quote, USCIS relied on INA provisions requiring a naturalization applicant to be lawfully admitted for permanent residence, which means that the applicant must have LPR status. Mr. Azumah satisfies that requirement, end quote, because he never lost his LPR status. No statute supports USCIS's reading of the naturalization statutes as requiring more from the phrase lawfully admitted for permanent residence beyond holding LPR status. And well, if read broadly, that is a massive holding that can be used to challenge USCIS's attempt to relitigate an LPR's receipt of LPR status during the naturalization stage. Check out footnote 5 too. For, as all three judges on the panel state, none of them know what USCIS actually means by 8 C.F.R. section 316.2b. Judge Richardson in concurrence calls it, quote, gibberish, end quote, that should be disregarded. USCIS still has authority to get around all of this by starting and having ICE litigate removal proceedings, explain the court, but without ongoing removal proceedings, well, this might be the most important immigration decision issued by a circuit this year. And so, you know it. Congratulations Ben Winograd and Ava Cayetano Benech for appellant. To be my own voice of reason, as I must do on a podcast where I am the only person. Don't get too excited. As counsel pointed out to me, the court's brief discussion and reliance on prior Fourth Circuit precedent might limit this holding to the unique entry-based issue directly at play for Mr. Azumah. This decision doesn't necessarily hold that LPRs satisfy the, quote, lawfully admitted for permanent residence, end quote, statutory language just because they're LPRs, even if they got that status in error or through fraud, and it certainly doesn't overrule prior precedent expressly holding that that phrase does require a substantive analysis. But I don't know, man. I don't see how the Fourth Circuit's discussion of 8 C.F.R. section 316.2b can logically mean anything other than the fact that USCIS's reading of the lawfully admitted phrase to require more than mere possession of LPR status is ultra-virus, the statute. Let's go. And that is Azumah v. USCIS. Next up, Bador v. Garland, published by the Second Circuit on July 11th, 2024. This case is about petitions to remove the condition on lawful permanent resident status, I-751s. And oh, wait a minute. This has got to be the direct review of the BIA's precedential decision in matter of Bador, episode 128. The BIA's precedential decision was affirmed by the Second Circuit. It is not a zombie. Mr. Bador and his U.S. citizen wife had not yet been married for at least 2 years when she, the wife, filed an I-130 petition for him. That means that when USCIS approved the petition, and Mr. Bador's I-485 adjustment of status application was filed and approved, it was only a conditional LPR status that he received, and the couple, like all such couples, had to jointly petition to remove the condition within 2 years of receiving the conditional status, absent some exceptions. The problem for Mr. Bador is that his wife withdrew her support after the couple filed their joint petition, so USCIS deemed that application abandoned and terminated Mr. Bador's conditional LPR status. That placed him in removal proceedings where, technically, he had the right to have an immigration judge review USCIS's denial de novo. Problem is, said the BIA eventually, was that there was nothing for the IJ to review. The joint petition was never adjudicated. It was withdrawn by the wife. Mr. Bador could have divorced his wife and filed, for example, an I-751 requesting a waiver of the joint filing requirement. And it seems that actually he did do that. But USCIS then denied that, holding that Mr. Bador hadn't shown that the marriage was bona fide, which is a necessary requirement to waive the joint filing requirement based simply on a divorce pre-removal of conditional status. So Mr. Bador sought review of USCIS's denial of the waiver to the joint filing requirement before the IJ. And remember, that all comes down to whether the couple married in good faith and didn't commit marriage fraud. But then in immigration court, quote, on cross-examination, he was questioned about an investigation linking him to a South Carolina-based marriage fraud ring. After a recess to confer with counsel, Mr. Bador withdrew his request for review of the good faith waiver. The IJ then adjourned the hearing, end quote. Yikes. At the next hearing, Mr. Bador admitted the fraud and sought an INA Section 237A1H waiver. Now, a Section 237A1H waiver would totally waive marriage fraud and let Mr. Bador keep his green card, if approved, of course, provided that Mr. Bador was a full-fledged LPR. But a conditional LPR? The BIA said no in its precedential decision. The only way to remove the condition to LPR status is through the I-751 process and by basing one's claim on one of the provisions contained at INA Section 216C1 or C.F.R. The Second Circuit affirmed that, kind of. Now, in technical terms, the BIA had explained, a Section 237A1H, quote, waiver applies to non-citizens charged with being inadmissible at the time of admission or adjustment of status due to fraud or misrepresentation. But Mr. Bador was charged as removable only because his conditional permanent resident status had terminated, end quote. The removability charge matters, even though it all comes down to pretty much the same factual thing. It's a marriage fraud waiver, essentially, but the context in which removal proceedings are being litigated matters to the BIA in matter of Bador. The Second Circuit did affirm, but it didn't go quite as far. It held that whatever the scope of a 237A1H waiver is, and it's not saying, it didn't apply to Mr. Bador here. To argue that he could benefit from the waiver, Mr. Bador of course argued that it's available where removability simply relates to fraud at the time of conditional admission. In so arguing, he relied, as he must, on Vasquez v. Holder from the 9th Circuit in 2010 and Aqua v. Sessions from the 7th Circuit in 2017. Frustratingly, the Second Circuit doesn't tell us whether it agrees with the 9th and 7th Circuits, which, if it had agreed, would likely permit use of a Section 237A1H waiver to waive marriage fraud underlying the denial of a joint I-751 petition, at a minimum. The reason that the Second Circuit isn't going to get into all of that, and why Mr. Bador loses here, explained the court, is that, quote, unlike Vasquez and Aqua, Mr. Bador lost his conditional permanent resident status because he failed to file a joint petition, end quote. It was withdrawn, remember? And failure to file a joint petition terminates the conditional status regardless of whether fraud was committed or not, explained the Second Circuit. Nor did the filing of a waiver to the joint filing requirement after USCIS had already terminated Mr. Bador's status, it seems, fix that. So, Mr. Bador remains removable and can't benefit from an INA Section 237A1H waiver. So actually, this case does not in any way really affirm matter of Bador's broad shot across the bow at Vasquez v. Holder, or if I recall, broad holding that conditional LPRs can't ever benefit from a Section 237A1H waiver. A BIA holding that I believe to date has not been affirmed, and of course, is no longer subject to Chevron deference in any circuit anyway. And that is Bador v. Garland. Next up, Aguilar v. Attorney General of the United States, published by the Third Circuit on July 10th, 2024. This case is about good moral character and pretrial detention. Mr. Aguilar is from Honduras and entered the United States without inspection in 2001. He has 3 U.S. citizen children and was placed in removal proceedings and applied for non-LPR cancellation of removal. But among many other requirements, that form of relief requires that a non-citizen show good moral character during the preceding 10 years, and INA Section 101F7 reads that a non-citizen can never establish good moral character if they've spent 180 days or more, quote, confined as a result of conviction, end quote. Remember those words. And well, Mr. Aguilar spent 1,332 days in pretrial custody for allegedly sexually assaulting his stepdaughter. He eventually pled guilty to endangering the welfare of a child in New Jersey and was sentenced to time served. So that 1,332 days. But he never technically spent any time in prison post-conviction. It's a long decision if you include the dissent, but that's really what it's about. Does pretrial detention that's converted into the term of imprisonment as time served after conviction qualify as, quote, confined as a result of conviction, as Section 101F7 requires? Yes, said the Third Circuit majority. First, the court held that the issue was properly exhausted, a claims processing rule and not jurisdictional requirement anyway, because in essence the BIA addressed the issue even if Mr. Aguilar might not have made the argument before the BIA. The Third Circuit just agreed with the BIA. Heck, the BIA apparently reached this issue 42 years ago in matter of Valdivinos, published in 1982. And I'm sorry, maybe it's the late Friday afternoon talking, but I was born in 1986, and I was about to type 22 years ago, which of course makes no sense, and then I caught myself and wrote 32 years ago. But 1982 was in fact 42 years ago. That cannot be possible. And yet here we are. Was the imprisonment really a result of confinement? Mr. Aguilar argued that all of that confinement was, quote, as a result of his inability to post bail, not the later in time entry of his plea agreement, end quote. And true, that probably was the proximate cause of his actual confinement. Does Section 101F7 include such confinement? Again, yes, at least under the facts here. Noting that Chevron deference was dead, the Third Circuit reviewed the issue de novo, instead of giving Valdivinos any deference whatsoever. And there we have it, people. Our first official Loper Bright helping non-citizens ever so slightly application. Didn't ultimately matter here, though. Quote, in our view, Section 101F7 is best understood to include the period of a defendant's pre-conviction confinement if it is later credited towards his sentence, end quote. This aligns with decisions from the 9th and 10th Circuits. In New Jersey, as with all states and the District of Columbia, sentences like this, for time served, include that pretrial custody as a term of imprisonment. They just deem it already served. The majority carefully explains that no one is arguing that Mr. Aguilar's 1,300 days would count if they weren't expressly made part of his conviction judgment. So the court is not punishing simply pretrial confinement. Quote, for instance, a defendant who spent 200 days in pretrial detention and is sentenced to 170 days imprisonment with credit for time served could still establish his good moral character, end quote. Remember that. Judge McKee in dissent believes that the phrase, quote, as a result of, end quote, in the statute indeed references approximate cause, and so pretrial detention shouldn't cut it, even if incorporated into the ultimate conviction. Judge McKee noted that Congress could have replaced the phrase with, quote, in connection with, end quote, if it wanted to do what the majority is saying. The dissent's analysis is certainly more statutorily based than is the majority's. But the dissent is not the majority, and Mr. Aguilar lost his case. And that is Aguilar v. Attorney General of the United States. Say goodbye to missed calls and wasted time on unqualified consultations. With Staffy Live, you get a dedicated team of truly bilingual and highly empathetic specialists answering the phones for your immigration law firm 24/7. Staffy Live specialists go beyond just answering calls. They qualify callers by asking the right questions, ensuring that only qualified consultations make it into your calendar. Plus, they don't stop there. Staffy Live can also handle follow-ups, so you can focus on what you do best, practicing law. Staffy Live is a service for immigration law firms only. And here's the best part. You can try Staffy Live absolutely free for 15 days, no strings attached. Just visit www.staffy.cc, that's stafi.cc, and click Get Started. Of course, use the code FREE to claim your free trial, or click on the links in the show notes. Short one from the 8th. Calvo-Tino v. Garland, published by the 8th on July 12, 2024. It's about asylum and related relief and protection. And it regards a mother and her minor daughter, the latter of whom suffers from a disease that causes a form of epilepsy. If not medically treated, the daughter could die and or get significant brain damage. The mother helps her daughter with everything that she does and accompanies her everywhere. There are limited medical resources for her in the small Guatemalan community that they're from, explained the 8th Circuit. And the petitioners allege that the mother, Miss Calvo-Tino, was persecuted by the hospital staff at the government-run hospital due to, it seems, their repeated incorrect medical treatment of her daughter. Sometimes physically abusive, as described in this decision. An immigration judge in the BIA denied their asylum claims, though, when they came to the United States, and the 8th Circuit affirmed. First, the 8th Circuit agreed that the harm suffered didn't rise to the level of past persecution. In the past, the 8th Circuit has, quote, rejected claims of persecution in cases only involving cumulative social indignities, low-level harassment, or verbal insults, end quote. Seems that's what the agency believed happened here. Although it was argued that hospital staff tried to kill the daughter and poison her, there was no evidence of that intent, rather than maybe some just negligent medical care, it seems. Or at least that appears to be what the immigration judge believed. Having failed to establish past persecution and not really arguing for future persecution, the 8th Circuit didn't even address whether the particular social group was viable. As to Convention Against Torture Protection, remember, government-run hospital, the 8th Circuit summarily denied it for largely the same reasons as the past persecution stuff, and because the court didn't see an individualized risk to the petitioners. So, Miss Calvo-Tino and her daughter lost their case. Told you it was a short one. And if you, like me, are wondering why Miss Calvo-Tino was the focus of all of this legal analysis when the facts all related to her daughter, it's almost surely because if Miss Calvo-Tino gets asylum based on what happened to her daughter and how it affected her, her daughter will also get asylum as a derivative. But if the daughter was the lead and only asylum applicant, the mother couldn't be a derivative on her daughter's case and would be left out to dry. Such is immigration law. And that is Calvo-Tino v. Garland. Concluding with the 11th Circuit, as it seems I often do, we have Alkotof v. Garland, published by the 11th on July 12, 2024. This case is about non-LPR cancellation of removal, administrative closure, and continuances. Mr. Alkotof is from Yemen. He came here on a tourist visa in 2006 and he overstayed. DHS initiated removal proceedings in 2010. In removal proceedings, Mr. Alkotof asked for time for USCIS to adjudicate the I-130 petition that his U.S. citizen spouse had filed, which, if approved, would make him eligible for adjustment of status in immigration court. The IJ obliged. But USCIS denied that I-130 because Mr. Alkotof's spouse didn't show up for the later interview, it seems. And then the couple divorced. A month after the divorce, Mr. Alkotof married a different U.S. citizen who also filed an I-130 petition for him, and that was approved. So Mr. Alkotof filed his I-45 adjustment of status application in immigration court. Delay and somewhat chaos ensued, and then USCIS revoked the I-130 petition, making an INA Section 204C finding, believing that the first petition was fraudulent and thereby barred Mr. Alkotof from being the beneficiary of any subsequent I-130 petition like the one that it had approved. All power to the agency, in immigration at least. Mr. Alkotof appealed that. The IJ continued the matter for a fifth time, and then a sixth time. Many years in by this point, and with the appeal of the I-130 revocation still pending, with the BIA I believe, Mr. Alkotof told the IJ that he had recently applied for a U visa because he had been the victim of criminal activity. Can someone explain to me why IJs don't have authority to review USCIS denials of I-130 petitions when removal proceedings are ongoing, or to approve petitions themselves? Seems like it would really expedite things and would be fundamentally fair. Anyway, Mr. Alkotof argued for administrative closure or a continuance because of all of these collateral things going on. Like George Washington and Hamilton, the IJ continued proceedings one last time. And the I-130 revocation appeal is taking forever, like years. And so, at this final hearing, with no relief immediately available, and a U visa technically approvable even with a removal order, the IJ denied administrative closure and another continuance, and ordered Mr. Alkotof removed to Yemen. The BIA affirmed that. Heck, at the time the IJ ruled, matter of castratum barred administrative closure. Also, Mr. Alkotof moved to remand so he could apply for non-LPR cancellation of removal, possibly newly eligible for it on appeal because of case law changes regarding the stop time rule and deficient NTAs. But possibly, or maybe only, his U.S. citizen son had recently been diagnosed with autism, so new facts for hardship. The BIA denied the motion. And the 11th Circuit had no problem with any of it. Limited things that Mr. Alkotof could argue on petition for review anyway. First, explained the 11th Circuit, no constitutional due process violation. Heck, in the 11th Circuit, quote, there is no constitutionally protected interest in purely discretionary forms of relief, end quote. Not even to how it's adjudicated, court? Like, say, if there was no process provided at all? How has case law gone so far astray? The 11th Circuit literally didn't consider the denial of the motion to remand for cancellation of removal adjudication for this reason alone, because it is a discretionary form of relief, so there can be no due process violation in regards to how it's adjudicated in the 11th Circuit. As to the denial of administrative closure and a continuance, well, that's going to be a hard challenge in any circuit. And it seems like the I-130 appeal was eventually dismissed and the 204C finding affirmed. So this then comes down to administrative closure or a continuance for the U visa adjudication. But hey, at least the 11th Circuit held that it had jurisdiction to hear the arguments. A due process challenge to a denial of a continuance or administrative closure requires that the non-citizen show that, quote, he was deprived of liberty without due process of law and that the purported errors caused him substantial prejudice, end quote. Not met here. Quote, to show substantial prejudice, a non-citizen must demonstrate that in the absence of the alleged violations, the outcome of the proceeding would have been different, end quote. This, even if the IJ committed error, said the 11th Circuit, really comes down to prejudice. No prejudice on the denial of the I-45 or a continuance or administrative closure to await it because there was no approved visa petition at the time, nor was there one ever, ultimately. Mr. Alkotof was never eligible for adjustment of status. Can't be a due process violation to deny adjustment of status when there isn't an approved I-130 petition before the immigration court. As to the U-visa basis, one of the bases for a continuance, at least, is a showing that you're likely to succeed on the collateral relief, and the 11th Circuit didn't believe that Mr. Alkotof had met it here. The 11th Circuit went through other continuance factors tethered to a pending U-visa and rejected them, a discussion pretty adverse to future non-citizens advocating for a similar continuance. As to administrative closure, well, no prejudice there either in the denial, because a non-citizen can still get a U-visa and even adjust when a final order of removal is issued, provided they get the U-visa. So, all losses for Mr. Alkotof. But on that last point, we at KKTP have a case right now where the non-citizen was ordered removed, and it became final before the BIA, but subsequently got a U-visa and adjusted to LPR status. Among other things, we're worried about what might happen to him or her if she or he travels and seeks to come back in. That right there is possible prejudice that should be argued in future cases like this. And wouldn't you know it, in our case, with the non-citizen already in LPR because he or she was the victim of crime, the BIA refused to reopen and dismiss proceedings on our motion. Prejudicial, says I. And that is Alkotof v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetseli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.